what makes an asylum case weak or strong? It's a very interesting question. So there are obviously, statutory bars to asylum that, make the case weak. I'm not going to talk about those because everybody's familiar with, criminal background or 1 year deadline for filing asylum and so on. I'll share with you, based on my experience, things that people did before applying for asylum that made their case weaker, or things that they didn't do that should have done during the handling of their case. One of the things that comes to my mind first is filing uh, a bare asylum application form. Basically, filing the I-589 without any supporting documentation or declaration, with the hopes to supplement this down the road when the interview is scheduled or when the court date is scheduled and so on. The reason why lots of applicants do this is to start their asylum clock going as soon as possible so that they can become eligible for employment authorization document after they file for asylum, 5 months after when they can file application for employment authorization. Um, but the downside of filing it early without sufficient supporting documentation is that that case is looked down upon. So unfortunately, there are many asylum applicants that file asylum applications with no real basis, just for the purpose of getting EADs, employment authorization documents. Or there are some asylum applications that people file and then they come up with stuff with basis, and then they come up with documents. They either pay, get forged documents, and so on. And this is very obvious. And once the USCIS sees a bare bone application with no supporting documentation, or sometimes even without a declaration attached to it, then it becomes suspicious, the reasons why this was filed, and without any supporting information or documentation. So that's one thing that I usually don't recommend. And as a rule, as a policy in our firm, we make sure that we collect all of the supporting documentation as much as possible, including witness statements, affidavits, and so on, and prepare a very thorough declaration and file it with the USCIS all at once. The other issue with sending a quick and random application with random declaration is that whatever you send to them sticks with your case forever. It's not that you can send a declaration today saying, this happened to me, and then down the road supplement and say, no, this didn't, but the other thing happened, or ABC happened, but now you're saying also there were other incidents which you didn't describe in your first declaration. That significantly weakens your case. So therefore, from the beginning of your case, make sure you prepare a thorough application, thorough declaration, and thoroughly gather evidence, which you need to file upfront with the USCIS. And there is also this wrong understanding that you can file an asylum application with the USCIS, give it a try. If not, then you have a second chance in immigration court, which is true. You have a second chance, but it's not the second chance in a sense that it's easy, it's not fast, and plus whatever you filed with the USCIS is going to be reviewed and considered at the second chance in immigration court. So it's best to prepare everything very diligently and carefully and thoroughly. The second thing that I often see is some people, maybe it's because of the naivety or because they have to, or any other reasons, they come to the US, they visit the US several times before they actually file for asylum. So they go back and forth. And sometimes they even consult with me and they say, oh, I have this basis for asylum. Should I file it? I'm planning to go back and return and do something, or sell my car, or do something else, and then I'll come back and file for asylum. And I tell them, well, how come? I mean, if you're applying for asylum, if you're stating that you cannot go back to your home country, and this is your chance to apply, you're here now, why would you go back? So each time an applicant returns to their home country voluntarily for any reason, that creates question. It doesn't mean that it automatically bars asylum, but it creates unnecessary questions. So if you can apply for asylum while you're in the US before going back and forth, then that's the better chance. Now, the arguments against those questions could be that, how come you went back to your home country? The argument can be that things happened to me after I went back. So somebody may have visited the US for a visit, then went back and then spent another 6 months or a year or more. Some visitor visas are valid for 10 years for some countries. So things might have happened between those two visits. But the bottom line is, in the asylum application, you have to indicate every visit to the US, and the questions come up that you visited US before, or not just the United States, some other countries before, and why didn't you apply? The other issue that I see often is um, asking for expedite requests. So as we know, the asylum applications take a long time until the interview is scheduled. The USCIS is severely backlogged. Some of the applicants wait for years for their interviews. And there is a process to ask for the interviews to be expedited. And sometimes, a lot of times, I get our current clients, we have hundreds of cases that have been pending for years. Sometimes they get anxious. They contact me and say, can we place an expedite request? Or sometimes we have new clients who have pending cases. They want to hire us to ask for expedite. And in the process of expedite request, some of the applicants are approaching it a little bit loosely in terms of the actual proof of the reasons to expedite. And I tell them that, look, you're sending this request to the same place that will be considering your entire asylum case. And if you make some baseless arguments to place your case ahead of everybody else, then you are damaging your credibility. And a lot depends on your credibility. So when you have an asylum case pending with the USCIS, you have an asylum officer who's going to be considering your case, your credibility plays significant role. So if you're put 100,000 cases behind mine, put me ahead of everybody else, and you're bringing some bogus reasons to do that, that's going to stick with your case. Even if they grant that expedite or deny that expedite, that's still going to be, something that they may consider. I'm not saying they will consider in every case, but they may consider and hold it against you if you're making ridiculous arguments. I always tell my clients, sometimes they say, I want to be heard first. This has been 5 years and so on. I say, okay, here's the deal. Imagine you're at the airport. There are 500,000 people in front of you, and you're telling everybody to move aside so that you can go first. You better have some strong, urgent, emergency reasons to do that. Otherwise, everybody's going to laugh at you, and they'll consider you not credible or ridiculously minded person asking everybody to move aside just because you're impatient, because you want to be heard first. Same thing applies here. If you're asking asylum office to move every case aside and have your case heard because you're tired of waiting, that's going to be looked down upon, and that's not going to work very well for you. The other obvious thing that makes asylum case stronger is hiring a competent attorney to help your case. And if we look at just statistics, the Syracuse University maintains statistics of asylum cases, the judges, the rate of grants, and so on. But they also have statistics of represented, unrepresented cases to see, what percentage of the asylum cases are granted when the applicant had a lawyer versus not. And just looking at the rough statistics, and I'm not even talking about the competence or the knowledge or experience of the lawyer. I'm just taking as a bulk, just looking at rough mathematical numbers. You have mathematically roughly about 2 times higher chance of getting your asylum approved if you have a lawyer. Again, just by virtue, if we take it as a bulk of statistics, having an asylum and immigration lawyer representing you increases the chance statistically by 2 times. So 2 times more chances of getting asylum approved. But of course, it's not only that, you also want to increase your chances even higher by finding the right lawyer. And that's one of the other things that I see, makes your case stronger or weaker is having an immigration lawyer handle your case is not a check mark. Just having a lawyer, again, we're looking at statistics, but it also means statistically, most of the lawyers are actually doing a good job. But uh, there are some law firms and lawyers that will just, they're sweatshops. They'll just fill out your forms and file it, and that's it. And they're not really doing much. So when you hire a lawyer, one of the things that you can do to increase your chances of asylum is find the right lawyer. And what it means is, look at their uh, first of all reviews, look at the information about those lawyers, how dedicated they are, what other clients. And when I say look at the reviews, I don't mean just look at the 5 stars and so on. It's there are ways to manipulate that one way or another. But read the substance of the reviews and see how responsive this lawyer, what other clients are saying about this lawyer in terms of their dedication and personal attention to the case. Sometimes I get contacted by some other lawyers from other jurisdictions saying, "Oh, my client has this interview at the asylum office. Can you attend this interview?" And I'm like, "I would be glad to, but I'll have to learn a lot about the case, and it's not going to be a $500 gig because I don't feel comfortable going to the asylum interview without knowing ins and outs of the case all the way." And I am kind of a little bit also, hesitant to do that because I don't think that an asylum client should be represented by a lawyer who's not planning. I mean, I understand there are situations that who's not planning to attend the interview, I was trying to say, but I understand situations there may be conflict in the dates, the availability, and so on. But what I see, unfortunately, some law firms, they're taking cases, they're just filling out the forms, filing it, and then when the interview comes, they're just the client is on their own. And what's the point of having this lawyer? So finding the right law firm, right lawyer is important. Also important is to listen to the advice of the licensed professionals. I'm not saying that they may not be wrong, they may be, but there are much less chances. Just like if you have, if you need medical advice, you'd probably go to a doctor. If you need to, build a structure, you need an engineer, an architect, so that it doesn't collapse on your head. The same way here is, the worst thing happens, and quite often I see people come to consultations because they failed in the first stage of the asylum case just because some friend told them that do this, I did this, and it's going to work. And just like as I said, if your friend tells you do this and you will be able to build a house which will not collapse on your head, you're probably not going to do it. Or somebody just survived the 5-story fall from the building doesn't mean that it's a good idea to do so. So well, I guess what I'm trying to say is that try to maximize your chances by listening to professional advice rather than random advice of people that either think to themselves or use you as a trial of their thoughts. They say, "Oh, if you do this, this is going to work," and then you're basically guinea pig for them to see if it's going to work, if they're smart enough or not. The other thing is, um, that makes asylum case stronger is using circumstantial evidence. What I mean by that is that anytime you're trying to prove something, there is a direct evidence, there is circumstantial evidence. For example, if you're trying to prove that in your asylum case that you were interrogated, beaten up, and then detained, um, and then you were physically harmed, what could be the direct evidence? Of course, the video of this occurring, but it's such a cliche and it's also very rare that there would be any video or photograph of this actually happening. It's probably not only rare, but it's probably not possible. Nobody's going to video police officers unlawfully beating you up. But I see that. I mean, I see sometimes I have clients bringing me photographs of them being detained and in handcuffs, and the police officer is posing together with them. I mean, it's such a cliche and it's so suspicious. I mean, these immigration officers and judges are not idiots. They know that in most of these third world countries, where most of the asylum applicants are from, you can bribe the police officers to dance for you or do, acrobatic shows. So it's not unusual to get someone in the police uniform, whether they have a general's rank or major or whatever, then they'll do this. I mean, they'll do many things in those countries for money. So I guess what I'm trying to say is that don't try to don't forge any direct evidence. And similarly, that people get medical reports saying that they were hit, punched in the head or face without any severe consequences. It's also suspicious. I mean, you don't go to a doctor just because somebody slapped you in the face. You may. I'm not saying it's impossible, but at the same time, it kind of becomes also suspicious. But the circumstantial evidence is something that you can gather after the fact. You can collect letters like witness statements, and again, circumstantial could be anything. Like, for example, if you were called to the police station, somebody called you on your phone, on your cell phone, from an identified number, and I'm just bringing you an example, and you've been invited to interrogation to the police station, and then if you have that missed call or the call on your cell phone, maybe you can take a screenshot. In some cases, you can actually video record somebody telling you that they're afraid to give you evidence, or audio record them and then transcribe it and then provide it. So there may be lots of, you can just imagine, there are so many different circumstantial types of evidence that you can use in support of your asylum case, and sometimes those are more effective than direct evidence. And finally, one of the things that I wanted to say about the asylum cases is making it weaker or stronger is using experts. Lots of applicants, they neglect to use country condition experts in their cases, or they use them wrong. The country condition experts are not just experts on the country conditions, but the expert has to render his or her opinion about your case. So sometimes what I see as a country condition expert is used, it's just an expert who's basically saying, yes, things are bad in this country and this is what happens and so on. No, the expert has to apply the country conditions to the facts of your case and render an opinion, and be upfront and insistive on the opinion. So that's another thing that is quite often not used, or sometimes I see that experts are not even used in the case. If the case is not as straightforward as there is a war or ethnic conflict going on, and it's clear that this is ethnic-based asylum, then expert is useful if it's not that type of straightforward case. And a lot of times those are like corruption, the countries where you have political opinion, which is not a straightforward political opinion. It's not traditional political opinion where the applicant was a member of opposition, participated in protests and so on. Then expert is extremely useful. So those are the things from experience that I see in the cases that could have been prevented or could have been done otherwise to make your asylum case stronger or weaker. Now, one of the most traditionally probably spoken about things that people think that makes their case stronger or weaker is changing the jurisdiction of their asylum case. What it means is that moving from one state to another, because the ratings of the judges in one state is higher than the judges in another state. And that is not always true. Even though, as I said, that Syracuse University maintains the statistics, but it doesn't mean that the statistics apply to your case. What I mean by that, so for example, we have some of the immigration courts which have a significantly higher rate of asylum denials. But your case, now the reason why they may have this significant rate of denials is the type of cases that those immigration courts have. So, for example, some of the courts have primarily immigration cases from Latin American countries where lots of applicants are coming to the US for economic reasons, and they may not have real basis for asylum. There is no not really. I mean, I'm not saying there is not, but it's just strictly looking at the volume of cases they have from those countries, and a lot of the arrivals from those countries are for economic reasons, then the rate of the denials is higher. By volume, by number of cases granted, probably Latin American countries get a lot more higher number-wise cases approved than many other countries. But if we look at the percentage, because of the volume of people coming here from those countries for economic reasons, which is not basis for asylum, their rate is higher. So if you have a case, for example, in one of those courts or in front of the judges, and judges different also get assigned different types of cases. So if you have a case in front of the judge that had 50 cases from Latin America before your case, and now you're coming from some kind of Eastern European or Central Asian country and you're asking for asylum, that might be actually better, because that judge might be more interested in your case and more motivated to approve your case. And that judge actually, despite of the percentage of the approvals or denials, might be not a bad judge at all. So I'm not saying there is no personal prejudice between the judges. There is, just like every other human being. Somebody has their own preconceived thoughts about one country or even just the system of asylum. I don't think that kind of person should be a judge if they have preconceived notion. Beliefs about anti-immigrant or pro-immigrant. But unfortunately, there are. So. But even the Syracuse University, if you look at that website, there is information about one of the judges, which had like 90% of the denial rate in one court that he worked, and then he had 80% or so approval rate when he moved to another court because of the types of cases. Okay.